welcome to Adrian Henderson from RWK Goodman. We have a great relationship with you guys.
Thanks, Lucy. Good morning, everyone. For those of you who don't know me, which will be most of you, my name is Adrian Henderson. I'm an associate solicitor in employment and business immigration law at RWK Goodman, and I'm going to be talking today about one of the most I want to say ever-changing, but I think turbulent would probably be a better way of describing the business immigration sponsorship legislative framework over the last few years. It's been a really a very interesting and also very up and down few years in this area. In 2021, we saw the biggest reforms to the business immigration framework probably ever, I think, as a result of Brexit. And this year, particularly, we've seen further changes, specifically in relation to the alterations on care workers being able to bring in their dependents, for example. We've seen changes in regards to the minimum salary thresholds that care worker and senior care workers are able to be paid when they're sponsored. And we've also, as April mentioned, we have a new government now. So we've got a new set of people in charge of the Home Office. So we're going to be watching this with a very careful eye to see if there are further changes or attempts to repeal some of the rather unpopular changes that have been passed over the last few months. So it'll be, interesting times, as they say. But today I'm going to be talking about sponsor license compliance. I'm going to share my screen. What I'm going to be talking about today is the compliance duties that all license holders must follow throughout the lifetime of their license. The thing to bear in mind here is that sponsor license acquisition and the ability to bring people over from overseas to work in your in whichever area you're sponsoring them in is an active there are very active duties. Holding a license is very active. It's not passive. It comes with ongoing and consistent compliance duties, which we're going to be going over. I'm also going to be talking about Home Office audits and the compliance visits that the Home Office do. I've heard this being described as CQC inspections on steroids. So for those of you who are, which is all of you who are CQC registered, obviously, you will be aware of the framework and the network of people from an external body coming in and poking around at what you're doing and checking you're all doing it correctly. Well, the Home Office is just another one of those, ultimately. So what we're going to be covering this morning is an overview of all of those duties. And also I'm going to be touching throughout on the specific issues that related to the care sector. So obviously this relates to health and social care visas specifically, but also when we're talking about things like due diligence checks on individuals, ethical recruitment, things like that. These are areas which are acutely pertinent to the care sector. So as we go along, we'll be talking about that. The chat function is open. If you have any questions that occur to you as we're going along, if you pop them into the chat function, and what I'll try and do is address those at the end, just so that I'm not kind of going back and forth consistently. I know that this is an area that people have a fair bit of concern about and are very keen to ensure that they're getting everything right for obvious reasons. So before we do go any further, I'm just going to move on to the shameless plug part of the presentation, which is just going over what services RWK Goodman offer to the health and social care sector as a whole. We are one of the leading firms in the country with a specific focus on the health and social care sector, and that covers a whole array of legal services for organisations and individuals within the sector. So obviously, employment and immigration, that's my bag. All things CQC, we're all over that. So CQC registration, challenging inspections and enforcements, and then along with that, things like safeguarding and inquests. We're also we have a comprehensive team that spend all day every day on that. Service user contracts and the more commercial sides of things, as well as are other things that we can assist with as our local authority fee negotiations. The mental capacity and court of protection, we have a comprehensive CPU team here who are one of the leading teams in the country on that. And on the more commercial side, things like business, sales, acquisitions, mergers of organisations, do not hesitate to drop me a line if you wanted to have a discussion on any of those things. So the Home Office compliance duties. The summary on this is that all sponsor license holders can expect to receive a visit from the Home Office compliance team at some point during the lifetime of their license. If you're very lucky, you might dodge one altogether. If you hold a license for not very long, for example, you might be one of the lucky ones. But what we tend to say to clients is you should expect it to happen at some point. So the important thing here, and the whole purpose of what we're talking about today, is to kind of get you audit proof, if you like, for that eventuality. And the purpose really is just to ensure what the Home Office is going to be looking for is your compliance with licence holder duties, and to check that they've all been complied with correctly. They will also test that the HR systems that you've got in place are robust enough to cope with the active duties that are imposed by the Home Office. This is ultimately something that they assess initially when you actually apply for the license itself. They'll have a look at your application and they'll assess for themselves whether they think that your HR systems are robust enough, and if they are, then you get the license, and during the inspections they just check that that is still the case, that they can still be confident in that assessment. Particular attention, and this is what we're going to be getting onto, is going to be paid to the three areas of personnel, record keeping and reporting duties, which I will get onto in detail in turn. So starting with personnel, this is something that I'm sure everybody here is fully au fait with. But just to go over this, you must ensure that you have these roles in place at all times. So the first one at the top of the tree is the authorizing officer of your sponsor license, and that's the most senior person within the team, within your team, within your organization, responsible for the recruitment of all migrant workers, and is ultimately also responsible for the SMS users. So this would be someone in a senior position. If you have more than one person who could potentially tick that box, then really you just have to decide for yourself who would be the most appropriate person who would fulfill that role. If you don't have if you have somebody who is the most senior person who fits that definition, but there may be somebody in a less senior position who could do the role, you still have to go with the most senior in that point. The next one on the list is the key contact, and this is effectively pretty self-explanatory role. It's the main contact between the Home Office and the organisation. It's the go-to person that the Home Office will use if they need to contact the organisation. And below that is the level 1 user. The level 1 user is the person who is effectively responsible for carrying out the day-to-day SMS activities, and that's the day-to-day reporting ultimately of what's going on with the organisation in the context of the sponsor license. It's the level 1 user who does that. The level 1 user is the only person who has permission to use the SMS, the sponsor management system, which is the online portal, which is effectively the gateway to all of this. The level 2 user, there is an option for the level 2 user. The level 2 user is the only one who is optional. You don't have to have a level 2 user. Generally, level 2 users are used within particularly large organizations with big administrative burdens when it comes to this kind of thing. The level 2 user has fewer permissions than the level 1 user, but can also access the SMS. It is particularly important that there is a level 1 user in place at all times, for the simple reason that without one, reporting becomes very difficult. The day-to-day management becomes very difficult. If you find yourself without one, you can add one by using a change of circumstances form, which is a way of adding one without having to go through the SMS. But it is important you have one at all times. You can also have multiple level 1 users, and for that reason, I think it is a good idea always to have 2 level 1 users in place in case one of them goes off sick or one of them leaves or disappears or leaves without notice or whatever. So you've always got 2 of them in place. Many organizations, particularly small organizations, have the authorizing officer, the key contact, and the level 1 user all as one person. One person doing all 3 roles. That's not unusual at all. It's really quite common as well to have the level 1 user as the key, and the key contact is the same person, simply because the level 1 user is there doing all of the reporting. It makes sense that that person is also the main point of contact from the Home Office as well. So that's one of the things that the Home Office auditors will be checking, that those individuals are in place, and crucially that those individuals are aware of what their individual roles consist of, and that they are, so the level 1 user, for example, knows exactly what they're doing when it comes to the key contact. Just a word about compliance in general. This is effectively the Home Office's position on compliance and sponsorship in general. And this is a quote from the Home Office. So what their position is that sponsorship is a privilege and not a right. The sponsorship system reflects that those who benefit directly from migration, such as employers, for example, should play their part, ensuring the immigration system is not abused. So effectively, the Home Office consider sponsor license holders as almost part sort of gatekeepers of the immigration system as a whole, as part of the structure to ensure that it ticks over sufficiently and that everything is done in accordance with law and published guidance. Significant trust is placed in sponsors, and they must ensure that they comply with immigration law and wider UK law, and not behave in a manner that is not conducive to the wider public good. And I'll get on to specifically what they mean by that. Those aren't simply empty phrases, that there are examples of that, which we'll get on to. So the sponsor duties themselves can be, broadly speaking, separated into 5 different areas, which I will unpick in turn. The first is reporting. The second is record keeping, complying with immigration law and Home Office guidance, complying with UK law more widely, and behaviour not conducive to the public good. Those are the sort of the 5 focuses. The main 2 focuses out of that is the first 2, reporting and record keeping. That's where most of your kind of day-to-day function will consist of as personnel in those areas. The other 3, slightly briefer, a little bit self-explanatory, but again, a little bit obvious, but again, it is important that we go over those points as well. So the first one I'm going to be talking about is record keeping. This is all of the records that you must keep and that will be checked during any compliance visits. If anybody has had a visit from the Home Office compliance people, you will know that they go through your records with a fine-tooth comb. It's part of assessing your HR capacity as well. The efficiency of your HR functions is going to be reflected in how good your record keeping is. Also, it's well worth looking at Appendix D, keeping documents in the guide for sponsors. That's available. Just you can Google it. There it is. It's on the gov.uk website. It's part of the Home Office's own guidance for sponsors. And Appendix D just has a list of all the documents that you need. So it's quite good to have that saved if on a on a document that you can refer to if you need to. All documents, the sort of bottom line is that all documents that relating to a sponsored worker must be kept throughout the period that you sponsor them, and which is ever the earlier of 1 year having passed from the date on which you end your sponsorship of the worker, or the date on which a compliance officer has examined and approved those documents. So it's 1 year following that. So if, for example, 1 year has not passed, so if somebody leaves, 6 months later, you get a visit from the Home Office, a compliance officer examines those documents and approves them, then the 1 year clock starts running again ultimately from that point. The sponsor license application documents as well. So the documents that you use, that you submitted when you applied for your license, so that will include things like the supporting documents, such as your proof of insurance, your proof of bank account, all of those sorts of things, and as well as the hierarchy chart that you would have submitted. All of those documents must be kept as well on file for as long as that license exists. Furthermore, in relation to the worker themselves, you must ensure that a copy of the worker's passport and entry clearance information is held if you brought them over and they were already in the UK at that point. So if coming to work for you involved entry clearance into the UK, then you must keep that information. Evidence of the worker's entry date into the UK if sponsorship from you is tied to their entry clearance. You would need to cross-reference that with their permission, with their right to work check. It's interesting to point out that this does not include people who you brought in on an undefined certificate of sponsorship. So people that you brought in who may have been working for another care home first, sponsored by them, then comes to be sponsored by you. It's only if their sponsorship by you is tied to their entry clearance. Recruitment activity needs to be kept. So how you got hold of them. So job adverts, for example, correspondence with agencies or third-party providers need to be kept. And if they came from a recommendation, if you headhunted them, for example, then evidence of that needs to be kept. This is the purpose for that is so that the Home Office can be confident that there was no abuse of the systems or processes at that point. Salary details, I'm going to get onto specifically. There are some specific details on salary, and also the job description and skill level that needs to be on file as well. So the practice of having specific employee files for all of your employees, which will include all of this information plus information about things like pay increases or disciplinaries, if they had disciplinaries, or grievances, if they had grievances, things that need to be kept on file. Ensure that you have those for each of your employees anyway, just as good practice, really. But for your sponsored workers, this is the information that needs to be kept in their particular file that can be inspected relatively easily. And then obviously with that, beware of ongoing obligations regarding the data of sponsored workers as well. So your data protection obligations, your data protection officer should be all over that and should be, their own work should be involved in this, just so that you are in retaining that data. You're sure that you have the correct permission to do so, and that you've got the correct justifications and all of that kind of thing. So on recruitment, I mentioned the recruitment. The information regarding recruitment needs to be retained. So keeping a copy of each relevant job advert, which must include all of the following. The job advert that you put out must have the job title and the location of the job. The main duties and responsibilities of the job, the skills, qualification, experience needed for the job, an indication of the salary package, the salary change, and the closing date for applications. Those are the things that should be contained on a job advert. If the job advert did not contain those, and you thought, oh, well, this was the one that we used, so we have to be genuine and honest about that, then by all means keep that. But you do need to, demonstrate that this information was made clear to the individual before they started. If it's online, the best thing, if it's an online job advert, the best thing to do is to keep a screenshot from the website. So if it was a recruitment website, for example, or an agency website, on the day that the vacancy is first advertised, and that's showing. So the name, this should be pretty easy, pretty simple from screenshots. The name of the website, the contents of the advert. Well, that's pretty obvious. That would be there. The URL or the website address, and again the date that the vacancy was first advertised, if stated. Okay, so if possible, all that information should also be there. So on salary, which is the final point on record keeping that I'm going to mention here, copies of the workers' pay slips should be kept on file. Again, it's not a bad idea to have that on file anyway, that you can recall that for any of your workers in case there is any dispute. I mean, it's just pretty decent to be able to put your hands on those if you need them. Evidence of the amount and frequency of all salary payments made to each sponsored worker. Again, that should be pretty easy for most people. And showing the transfer of each payment into the named worker's bank account payroll. Information from payroll should be able to supply you with that information. But record keeping specifically in relation to the sponsor license, that should be kept there for those sponsored workers, and a copy of any contract of employment or written statement of employment particulars. Again, just basic due diligence means that really should be kept on employees' files anyway. So that shouldn't be particularly difficult or particularly burdensome under the circumstances. And also just other points about general worker documents. So the individual's right to work check, okay, that should be done. The worker's entry date into the UK, if they have entry clearance, so a passport stamp, for example. National insurance number, again, you'll have that anyway. Payroll should have that, but keeping it on file for this specific purpose as well would be a good idea. History of the worker's contact details, so residential addresses, emails and phone numbers that they've had in the past, that will need to be kept. A copy of the DBS check if one is required. I imagine it's all required for all of the roles which we're thinking about here, so that needs to be kept. And a record of the workers' absences as well, that also needs to be kept on file. Okay, and that needs to be that should be inspected if needs be. So this is all, again, ensuring that your files are up to date and include all of this information. Should be should go some distance into, as I say, audit proofing your systems. By the way, don't bother about scribbling all of this down. I will be sharing the slide with Lucy and Michaela so that this can be distributed. So on the right to work checks, it's worth mentioning as an aside, but also something which is kind of, it is important in any event for the inspections here, are right to work checks, and the right to work checks may be inspected by the Home Office, by the sponsored workers and workers in general. Okay, and this links back to one of the general duties for sponsored workers, which is overall compliance with UK law. So right to work checks are, whilst they are not necessarily directly linked to sponsorship, you have to do it for anybody, regardless of whether they're sponsored or not. It is something that's likely to be checked up on by auditors. It is part of the duty to prevent illegal working. So again, as I said earlier on, it's all linked up with the idea that license holders are there to act to an extent as part gatekeepers of the immigration system. So just to go over this, and again, this is something that you all should know. I mean, obviously, ultimately, I could do an entire session just on right to work checks, but in brief, checks must be done on all employees prior to their first day of employment. They can be done in one of three ways, either on paper, online, or using a third-party provider. The system at the moment is leaning quite heavily towards online. There has been since about 2022, when the documents that it was okay to check on paper reduced. There's clearly a move. I think eventually the whole thing will go online, but the paper documents, the Home Office keeps lists of. There are actually 3 lists that the Home Office keep: List A and two lists called List B of acceptable right to work documents. List A includes things like UK passports, things like that, and List A is documents that denote a permanent right of residency and right to work in the UK, whereby you do that check once and you keep it on file. You don't have to do a follow-up check. List B, anything on List B, denotes temporary right to work in the UK. What you need to do with those documents is diarise the point when those documents expire and then do a follow-up check at that point. The online, which I think a lot of you will be used to doing, that's done using the online right to work check with the employee share code, the employee using their share code. Very, very simple. The results are completely idiot proof. They have a picture of the person's photograph, their name, their details, and precisely what they're allowed to do whilst they are working, whilst they're in the UK. They'll either be sponsored by you. This also includes things like if you employ students, for example, there will be information there on the parameters of their permission to take paid employment, and also what is frequently becoming very common and also something of an issue at times is the right to employ people who are sponsored by other organizations for supplemental employment for 20 hours a week. So those sorts of things, it will be very clear on those. If somebody does not have a share code, you can use the employee checking service, which will give you that statutory excuse for a limited time, usually 6 months, whereby you would do a follow-up check to ensure that person does indeed have the right to work, or indeed a follow-up check on the employee checking service if needs be. In terms of record keeping on that, you must keep a record of every document you've checked and the date on which you conducted that check, and you need to keep that for the duration of the employment of that individual and 2 years after that individual has left as well. That is something that Home Office auditors may check, and they might check this on sponsored workers. They may check it on other workers as well, again, to ensure that you are generally complying with UK immigration law as well, which is an important, sort of tick box to tick for them, that you are doing that correctly. A word about the statutory excuse on right to work. This is also worth mentioning. Employing people who do not have the right to be in the UK is an obvious no-no. You're not allowed to do that. There are sanctions for doing so as well, both in terms of civil and criminal penalties, which I'll get on to. However, it is also worth mentioning the statutory excuse here. So the statutory excuse effectively says that if you have done the checks that are prescribed by the Home Office, and the result of those checks showed that the individual in question had a reason, had a right to be in the UK, then you will be protected from any civil penalties by virtue of the statutory excuse. This basically means that if you are not expected to be an expert on fraud, you're not expected to look past things which clearly show that somebody does indeed have the right to be there. So effectively, if you're given a false document, you'll only be liable for civil penalty if it is reasonably apparent that it is false. Okay, you're not expected to be an expert here. You're not expected to use any, expensive technological aids to see whether or not these documents are forged or not. There is a definite common sense approach to this. So therefore, if something has slipped through the cracks, or you have been genuinely hoodwinked on this, you will not be penalized as a result. The things to look out for are reasonably obvious things. If something doesn't look, it's a classic thing, isn't it? If something doesn't look right, chances are it's not. But Look for things like changes of name. Changes of name can be perfectly innocently explained. Somebody getting married, for example. And if there is a change of name, just get some additional evidence, such as a marriage certificate or proof that they've changed their name or something like that. Photographs are tricky. We have had clients come to us and saying we've done a right to work check and the person in the photograph clearly is not the person who we think we're employing. That's a fairly obvious one. Age is an interesting one as well. If the document shows an age that the person clearly is not, I mean, God, you have to be sensitive on that. You can really put your foot in it if you get that one wrong. If you say you're never that old or young, and they in fact are, so be careful on that one. But it's things like that you need to be looking out for there. But bar those sorts of points, you will retain the statutory excuse. Okay, so moving on to reporting. This is again, this is another part of the active duties that you need to do throughout the lifespan of the license. You must report certain information or events using the SMS. So this is the level 1 user's duty within the set time limits. Any information reported about a worker's non-attendance, for example, or non-compliance, or their disappearance may be used to take information against them and you if it is not done in time. But if you are reporting that legitimately, the action will be taken against them. So do be aware of that. So there are, broadly speaking, quite crudely speaking, a group of there is a category of events that must be reported to the Home Office within 10 working days, and a group of actions and events that must be reported within 20 working days. So within 10 working days, which is the one on the screen now, this generally speaking relates to the workers themselves rather than the organisation. And this is, for example, if the worker doesn't start the role for which they are being sponsored at the particular time, that obviously must be reported, as well as any reason given. And the most obvious ones are things like missed flights, illness, bereavement, things like that. That's pretty clear. These are 10 working days, by the way, not 10 calendar days. If the worker is absent for work for more than 10 consecutive working days without permission, then you need to report. That's 10 consecutive working days. And this also implies that you do not have to report every time somebody is off. Every time someone's off, every time somebody calls in sick or takes leave or whatever, you don't have to report that. It's only when they have been 10 consecutive working days AWOL, effectively, that's when you have to report. If a worker's employment ends earlier than it's shown on the SMS, that must be reported, and it's good financial sense to do that because it means that you'll probably get a part refund on the immigration skills charge if you do that, because the money that you spent on that won't have been used and you can get that back. And also if you stop sponsoring a worker for any reason at all, so if they leave, if they are if they are dismissed, or indeed if they obtain indefinite leave to remain and they have independent right to be in the UK and you no longer are sponsoring them for that reason, that's another reason why you would need to report that within 10 working days. The changes to the employment of that individual, so promotion, change of work address, change of salary, change of duties, things like that, that must be reported. Now, the interesting thing about that is that the change of role can only happen ultimately without a fresh certificate of sponsorship if it's within the same SOC code. Okay. The frustrating thing about this, as many of you will know, is that care workers and senior care workers are not in the same SOC code, and this causes real headaches sometimes for people who want to legitimately promote them from one role to another. Ultimately, what that means is you have to issue them with a fresh certificate of sponsorship, and they need to apply for a fresh visa via a change of employment application, which is a pain. I don't know why they've chosen to separate them into different SOC codes, but they have, and far be it from us to query the infinite wisdom of the Home Office. And the other one, which does not relate to the employee themselves, is the change in the size or the charitable status of the company. That also needs to be reported within 10 working days. The reason for that is because when you apply, when you have to pay things like the immigration skills charge, or the various COS charges, that will depend on the size of your company. If you're a small company, or if you're a medium or large company, if you switch between those categories, then you will need to report that as and when that happens. Also, charitable status. If you either gain charitable status or lose it, that needs to be reported as well. And with those reports, the reports relating to the worker include the worker's personal address, phone number, and email address in those reports as well. The second point are changes you must report within 20 working days, and these are more focused on the organisation itself. So change of company name or the name of any branches that fall under the sponsor license, that must be reported within 20 working days. Any sale of all or part of the business, and also involvement in a merger or acquisition. So if you inherit another company, that must be reported within 20 working days, specifically the details of any sponsored workers whom you inherit as well. That must be reported. That's very important that that's reported within 20 working days, because if it's done correctly, then they will simply switch over to your license. If you cease trading or go into an insolvency procedure, that needs to be reported within that time frame as well. Obviously, you will have already reported the fact that you're no longer sponsoring the people if you stop trading in most parts, and also substantially changing the nature of your business. If you do that, that will also need to be reported. Conviction of a relevant offence as defined in the Home Office guidance, that needs to be reported. Obviously, nobody on this call would do that, but I need to mention it anyway. And you must immediately, this seems obvious, but you'd be surprised, you must immediately give the police any information that suggests any worker you're sponsoring on any route may engage in terrorism or criminal activity. Okay, so be aware on that as well. So coming on to the next point, so I'm going to talk a little bit about complying with UK immigration law and Home Office guidance. I want to leave enough time for some questions as well at the end of this, so I'm going to try and go as quickly as I can through these points. Some of these may appear obvious, and I'm sorry if they do. I'm sorry if this is obvious to a patronizing degree, but it is worth pointing out, and I'm going to get into why it is possibly a little bit more nuanced than it immediately looks. So this includes things like only employing suitably qualified individuals. Well, yes, obviously you'd think, but it's important within the area of senior care workers and nurses. It may not be as obvious. So those of you who employ nurses will be aware of the time frame that's needed to allow them to acquire the sufficient NMC standards. Senior care workers as well, just be aware that senior care workers and care workers are divided by two areas, really. One of them is their responsibilities on things like their ability to supervise and responsibilities of supervision on shifts. And another one is formal qualifications. Okay, so if they don't have formal qualifications, they will not be suitably qualified for that role, but you can employ them as care workers. Not employing individuals without necessary immigration permission. Obvious that, again, that's an obvious point. It goes back to the right to work checks having been done correctly. This includes people who you're sponsoring and people who you are not sponsoring. Not assigning certificate of sponsorships when no genuine vacancy exists. You would be, again, that does sometimes happen where sponsors think, well, it doesn't exist now, but it will exist in the future, we think. It has to be a live vacancy that exists at the moment. Only allowing the worker undertake what is permitted in their conditions of stay. This will be more obvious for people you're sponsoring than people you are not. Obviously, people you're sponsoring must only undertake work under their particular job title. But people who you are not sponsoring, who may be subject to immigration control, so for example, people on the 20-hour supplementary work route, or students, for example, who have parameters on what they're allowed to do in terms of paid employment, be aware of that as well. Only assigning to a COS to a worker who is capable and willing to fulfill the role. Yes, that's pretty obvious, but do be aware as well of using third-party recruiters. I've spent a long time over the last few months doing training on ethical recruitment and modern slavery, and sometimes that involves being vigilant to people who may be subject to unlawful practices by third-party recruiters, and being aware that you are yourselves fully engaged in the recruitment process of any individual at all, including those brought in by agencies and third-party recruiters, and complying with general UK employment law, which I will get on to in a second. Complying with wider UK law, obviously complying with the law, everyone has to do that. It shouldn't be something that you have to necessarily look out for, but in the context of a compliance visit, that is something that will be looked at and can and will have an impact on your license itself. So that includes things like complying with UK employment law, national minimum wage and working time regulations being a key point there. That is something that sometimes slips off the radar for certain people. An example of that is when the going rate for the roles that you're sponsoring goes up, and so does the national minimum wage. But the going rate goes up to a point that's actually below the national minimum wage. You still have to pay them the national minimum wage. Okay, so don't ignore that. That's something that should be clearly on your radar when that goes up. Tends to go up every April, so it's just worth keeping an eye on that. Complying with the duty to prevent illegal working, so right to work checks, as we've already mentioned. Being registered with a necessary regulatory body like the CQC, for example, that is something that will be looked at as well. That's something generally that the CQC registration is something that generally the Home Office can check up on without you needing to prove it. They can do that themselves. Holding planning permission to run the business if it's required. So if you are looking at acquiring another home or buying a building or a property that might involve a change of use, for example, from its previous use to a care home, for example, holding that planning permission is all part of complying with wider UK law. DBS checks if required for the role. Again, I've no doubt that this is right in the forefront of your minds whenever you recruit people, that's done. And ensuring, not ending, ensuring that employment law standards are fully complied with, including Equality Act compliance. Okay, so just making sure that there is nothing there that you can be caught out on in relation to that. With the Equality Act, and this is also linked to the further duty of not undertaking actions that is conducive to the public good. If you do breach Equality Act compliance, it's a double whammy really. You will potentially face a claim in the employment tribunal by the employee themselves, but also the Home Office will take quite a dim view on that in terms of your sponsor license and its future, basically. And very quickly, behaviour not conducive to the public good, again, seems obvious, but is worth mentioning. Fostering hatred or inter-community division, fomenting, justifying or glorifying terrorism. And again, the points there regarding rejecting the rights of or discriminating against other groups of individuals. And I've mentioned the 9 protected characteristics there under the Equality Act. And again, contravention of modern slavery laws and other unethical recruitment practice is extremely pertinent with the health and social care sector. So I would recommend you look at the Code of Practice for the International Recruitment of Health and Social Care Personnel in England. It's guide, so it is technically optional, but it is highly recommended. So very quickly, The visits themselves can happen either on notice or without notice, so they can simply just turn up if they want, and they'll either happen because you happen to be next on their list for a visit. If you are, then they really should give you notice. But they can also be triggered by something else that can trigger a visit. So that can be something like the report of a minor breach of compliance. So, for example, if you report something late outside of that 10 or 20 day working day period, that, and say, I'm terribly sorry, we missed this, won't do it again. Quite often the Home Office will say, okay, thank you for letting us know, just be aware in the future, blah, blah, blah. But they may decide to follow that up with a visit. A merger with another organisation triggering 2P, whereby you inherit other sponsored care workers, that might trigger one. Unusual activity on the COS. So if, for example, you are you're ordering another 30 COSs out of the blue, that might cause them to think, oh, hello, what's going on here? And also additional branches being added to the license. They may want to satisfy themselves that compliance is still taking place regardless of that expansion. So that might trigger one. During the visit itself, a full check of all records held on each employee and the sponsored license application process will be checked. Checks that all records and all information on the workers held by the Home Office corresponds with the reality. Okay, so that's really just a check that you've done all the reporting that you should have done and that there's nothing out of date. Checks that CQC registration is up to date, and checks that the general check that the HR processes are sufficient to be able to cope with the compliance demands. That should be obvious from your file keeping, things like that. Checks that the right to work checks have been carried out properly, as mentioned, not just on sponsored workers, and also interviews with key personnel. You can expect authorising officers level 1, and that should say level 1/2, not level half. Level 1 users and level 2 users. It's come out half, so apologies for that. And key contacts, and also interviewed with sponsored workers as well. Okay, so that can happen. So the scary bit, which is something I'm just going to finish up on. What happens if you do fall foul of the standards? Well, ultimately, your license can be revoked, and it can be revoked with a cooling off period of at least 12 months, whereby you will not be able to apply for a new license before that time has elapsed. You can have your license suspended pending further investigation, during which time you will have the opportunity to make further representations or answer questions that have been made. Your license can be downgraded from A to B rating with a time action plan. So if it's downgraded to a B rating, you still hold your license, but you will not be able to use it by sponsoring any new individuals. During that time action plan, you will be given targets to meet by the Home Office, and if you meet those targets on time, it will be bumped back up to an A rating. And just a couple of words about the sanctions for employing an illegal worker. If you are found to have employed somebody without the requisite permission, the civil penalty, which is where you have inadvertently done it without meaning to, there is a fine of between £45,000 and £60,000 per illegal worker. And if you have willfully employed an illegal worker, that's a criminal penalty of an unlimited fine or up to 5 years in prison. So make sure you don't do that. And then revocation, just a few things of revocation will happen if obviously you cease trading, you cease to meet the requirements of the route, there is a serious systematic breach. One of those two things is the most common, really. If you pose a threat to immigration control, if you committed a relevant criminal offence or been issued with a specific civil penalty, or if you engage in behaviour not conducive to the public good. Finally, I'm just going to, the final slide I've got here is just audit proof yourselves. Just do a complete internal audit of all records of employee files. Do a complete internal audit of all right to work checks of all employees, regardless of their immigration status. And also check the SMS to ensure that the current records at the Home Office are compliant with the reality of the situation in regards to both employees and the organisation. And also another shameless plug here, mock audits. We do carry out mock audits for people where we can come and visit your organisation and pretend to be Home Office compliance business, we will do all of that and then give you a mock report about what is likely to happen if this was for real, and also recommendations for you to improve. So I haven't left very long at all for questions, so apologies for that.
No, that's
So
good.
are there any questions that any of you have in relation to anything I've said?
Whilst we wait for questions to come in, I haven't seen any come in yet, but with the mock audit, would you also talk people through things they might not understand? For example, the Home Office SMS system, things like that. Would that be
Yes,
part
absolutely.
of it?
I mean, if there are fundamental points that people are concerned about, like use of the SMS, I think the good thing to do is to get some training beforehand, because I think if during the visit it becomes apparent that people are not really aware of how that works, I think that's going to be an immediate problem. So if there are more kind of elementary points that you need training on, or that just needs to be, you need going over on that, then we'll probably have to have a chat about you before that on a more sort of basic training level, I think.
I think going forward as well, Adrian, we've talked before, haven't we? But we're going to be doing some specific shorter videos on some of the specifics that we constantly get queries about. There's a big move at the moment about modern slavery and sort of avoiding that, obviously, but I think there's some wider questions as well that I think you and I can look at topics wise.
I
that we
think
can then host.
With modern slavery, the big focus on modern slavery is the use of third-party recruiters, bogus, dodgy ones, really, that you shouldn't be touching with a barge pole. As I said, if on the slide is the guidance, the Home Office guidance on international recruitment for the care sector. It's not, as I say, it's not law for private providers. It is law for the NHS, but it's highly recommended. And if you are concerned about inadvertently, because modern slavery laws and for at this level and is frequently about accidentally sleepwalking into breaches of the law rather than willfully committing acts of modern slavery, and it's so the training is really designed, again, it's to safeguard against that happening, really, the things to look out for. Timescales.
There you go.
Why are they taking so long? Well, so I'm assuming you mean undefined certificates of sponsorship. Undefined certificates of sponsorship have always taken about 16 weeks to come through, unless you use the priority service. I don't know why, but that is the standard. So the standard for that is 15 weeks. If you want to speed that up, then you can use the priority service. I don't know what the current length of time is to get a license itself. I don't think it's that much, but they are using priority service. It is still taking 50 weeks. I mean, I don't know. It's the Home Office being the Home Office. I mean, every time we get a piece of information from the guidance about from the Home Office about the length of time it takes to do things, we always have to take it with something of a pinch of salt. It's always an estimate. They are stretched. There is an enormous backlog for various things that case workers are being assigned to do. So, for example, an example of this is if a worker loses the right to be sponsored, what's supposed to happen, say if they lose their job, or if the license holder loses their license, what is supposed to happen is the Home Office writes to the worker curtailing their permission with a 60-day notice period. Now, that 60-day notice period is supposed to take place pretty quickly, and it only takes effect once that notice has been served. There is a huge backlog of notices not being served. We came across a case the other day where somebody had been waiting 2 years for their notice to be served, for that 60 days to start running. That gives you some impression about how threadbare the Home Office is at the moment. Is one of the things where I am keen to see if the change of management at the Home Office that we've had in the last couple of weeks makes any material difference to this. We obviously don't know, neither do we have any control over that, unfortunately. So I'm sorry I can't be more help, but ultimately the reason it's taking so long is because it's just because, sadly.
Yep.
If you're using the priority service, that's good. I would encourage people to do that. It's supposed to only take 10 working days under that circumstance, but if you are still waiting that long, then I'm really sorry.
Fabulous. There's another can of worms we could open, which is about national minimum wage and working out that with regards accommodation, which quite often comes up with with regards immigrant workers. Dare I open that can of worms now, or do you think that's worth us doing a separate video on that?
I think it may well be worth us doing a separate, but if only to say that it does affect, accommodation does have the effect of ultimately bringing wages down, or is considered meaningful consideration for the purposes of that. It's interesting. It's not meaningful consideration for the purposes of income tax, but it is for the purposes of wages. So, and ultimately to ensure that people aren't saying, okay, well, here's your accommodation, we're not going to pay you anything. I think that's the sort of nuisance they're trying to stamp out. But yes,
but I think
ultimately, it is something that probably requires a separate focus, I think.
Because I think one of the confusions with providers or employers is that, well, that's fine, I don't take it out of their wages and I'll charge them accommodation separately, but that still has an effect on their NMW, doesn't it? Yeah. Yep. And I think there's a little bit of grey area there sometimes. So
if they're not taking it out of their wages, that's fine. I mean, they that's okay. What they need to do is if they are providing accommodation, they just need to be, and we can go through how exactly to safeguard against that. It's also worth mentioning that on that point, there are other things that you can you can recuperate from employees certain things, like if you've offered to pay their visa fee or their or other sort of ancillary costs. That can be, that can be recuperated, but accommodation for national minimum wage can't. So it could be worth us doing something where we say, how do you deal with the finances of all of this? And because it's, apart from anything else, it's expensive, isn't it? Sponsoring people, we all know that.
It is, and I think we all have our best intentions, don't we, to make sure that the people that we bring over have a nice life here and that their families can settle and they, and certainly most care homes I know, and I'm sure everyone in this room is the same, we're little communities, aren't we, that look after each other. So just trying to make sure that we all keep our heads above water.
What we try and do is we try and ensure that with the training, it might be worth doing that in terms of ethical recruitment, because it's linked to the idea of financial exploitation and debt bondage and all of that kind of thing. So it's probably worth including all in that
fabulous
bulk.
Lovely. Well, that was very comprehensive. Thank you, Adrian. And I didn't expect anything less, and it's always an excellent guide to everything. Thank you, Adrian, for your time. Thank you, everyone, for coming along.
Okay,
thanks so much, everyone. Cheers.
Bye-bye.
Thank you.